I'm culling them to some extent. Here's a question. Private investigator. How do I find and hire a good private investigator for custody issues? Yeah, that's an interesting question because there's not a real good data bank for that purpose. I'll tell you that experienced domestic relations lawyers in virtually every city, we have those contacts. And I don't know what city that this is from, but if you hire somebody who just does domestic relations, then I'd be very surprised if they don't have a good contact. And you want to do this through your attorneys. I'm not trying to encourage you to spend more money on lawyers, but really if you're at the point where you're thinking about hiring a good investigator, you got to get your lawyer involved. You can really screw things up. And by that I mean you can create very unfavorable testimony. Sometimes I've had guys who've hired a private investigator who's been overreaching and who's been unreasonable, and later there was testimony by parties who were witnesses to his shenanigans or whatever his actions were, and it ends up putting a lot of unfavorable impression in the judge's mind about my client. So I think that more often than not, if you're going to use a private investigator, go ahead and hire a lawyer that knows somebody that he or she's comfortable with and do it that way. Let me tell you that there's also something that is unfavorable about private investigators. It's almost like recording conversations. There's a certain taint to it. And in all of us, if you step back for a minute, you think about what is the impression that it creates. Well, if somebody goes to the trouble to hire a private investigator to do something secretive like that, then there needs to be a pretty good payoff. Otherwise, you can just look kind of conniving and devious yourself. So whenever I'm having a client and he's in a jurisdiction where it's legal to record a conversation in which he participates, then I always think about, are we likely to get some substantial payoff from this? And if the evidentiary value outweighs the potentially unfavorable impact that this might have, then sure, we'll go forward and do it. Similarly with respect to private investigators. And again, at the risk of repetition here, you got to get somebody that understands what they're doing. They go about it in a professional way. They don't break laws. They don't create scenes. They don't get caught in positions that embarrass you, doing things that embarrass you. So do it through your lawyer. John submitted this question. I am married, but verbal fighting between me and my wife has strained the marriage to the point that we're discussing divorce. We have 2 children, a 3-year-old and an 18 months old. My wife is from Chile. Is that how you pronounce it? Chile, Chile. And has expressed that if we were divorced, that she would take the kids to Chile. She is also always the one to bring up divorce in our fights. In a recent fight, she said that she knows that it would be illegal for her to take the kids to Chile to live without my consent, but that she might do that anyway. The question is, how can I protect myself in future actions? As you might expect, there's nothing that's completely fail-safe here. There's no method I know of to where we can in advance get an order that's going to pull her passport. You would have to have pretty strong evidence before the court's going to intervene in that sort of heavy-handed way to pull somebody's passport merely on an allegation. So all you can do is you can commence the action which triggers the court's jurisdiction in that state. At that point, she is under the jurisdiction of the court. The children are under the jurisdiction of the court, and what action she engages in there, are subject to the court's sanctions and whatnot. But until you do something like that, none of that has happened. So when you're in your normal state of a marriage, then it's okay to take the children, assuming they have the passports and whatnot, to take the children to visit in another country. So I think that you're put to a position, John, where you have to make a decision. There's a sort of fork in the road here. If you're wanting to do a preemptive strike and sort of prevent or minimize this probability, then it does require that you take action. You file something with the court. Now, I've not suggested that you have to file a petition for divorce to trigger that jurisdiction of the children. You could file in most states a petition for legal separation, for example, and maybe even a couple other items that are of a family nature. They're in family court in your state that will trigger it. That's what you want. And then you file for an emergency hearing. In that emergency hearing, you can ask for some sort of relief that would prohibit her leaving the state, whatever it might be. I don't think simply on the evidence that I have here that you're going to get a judge that's going to order that she surrender the passport. But that's the best you can do. Now, let me say that beyond that, there is a convention, it's called the Hague Convention, by which a number of countries sign on to enforce laws between each other and domestic relations laws particularly. And Chile, I'm sure, is a signatory with the Hague Convention. What that means is that they will enforce, they'll respect an order issued by the United States. But you don't want to be in that position. It's a lot of money and it's a lot of delay and a lot of time. I think that you have to make the decision if you're at risk. And if you think you are at risk, you need to move forward. Let's see. Cliff, motion to modify. We currently have a court-ordered visitation child support agreement. The order took into consideration both of our incomes, the fact that my ex moved out of state 3 weeks prior to the trial on the merits, and both of our work schedules at the time were different. The situation has changed. My schedule has changed from 6 on, 4 off, I guess working 6 days, off 4 days, to a traditional work week. My ex started a normal full-time job and moved to another state. And again, I assume that this move out of state was with the permission of the court. It says all this made the following old visitation schedule problematic. Additionally, Meg's new job brings her income on par with mine. So it sounds like you might have a substantial and continuing change of circumstances. That's the magic phrase or bar that allows you to go into court for a modification. One, do we have to formally modify the court order, or can we jointly agree to simply adjust the schedule? You definitely should not jointly agree to do anything that's not signed off by the court because it's totally unenforceable. Now, I can't tell you how many guys fall into that trap where deliberately or not, their ex-wife or wife says to them, we can enter into an agreement between ourselves and let's do that instead of having the court issue an order. That's not a good idea. It really means that whoever has primary custody of the children effectively will control when and if they follow that schedule at all, because there is no legal effect to anything you do that is not signed off on by the court, on which the gavel does not go down. So as tempting as it is to avoid the expense of lawyers, and believe me, I understand that, it doesn't make sense. You've got to hire a lawyer, and it can be called a consent order, so to speak, or a consent modification, which is comparatively little cost. You each you prepare a motion. Maybe one of you files the motion. That's you, incidentally, not her lawyer and her. So you and your lawyer, you file this motion with the court, and you attach to that a proposed order. And then once that's filed with the court, then the parties can appear in court and they can both sign it, and that's that. Or they can even sign it in some states in advance, and the judge signs off on it, maybe with no testimony. Again, it depends on your state. So it can be very quick and very simple, even in the most onerous of states, to do a modification by consent. Now, incidentally, the judge always has the discretion to overrule even a consent deal between the parties, just so you know that. But do I think that's likely? No. It's very unusual that a judge is going to be that insertive in the parent-child relationship where both parties are in agreement. It's so rare, incidentally, that the judge has the opportunity to have both parties in agreement. It may be not so much rare, but so welcome that I think a judge is unlikely to disturb it and invite a trial. In this case, I would say that the fact that the schedules have substantially changed and that the child support, there's more than a 20 or 25% change, presumably based on this information, that would create a presumption that there's this substantial and continuing change of circumstances. Let me speak about each of those. Regarding modifying as to new circumstances, some states are different on this, and it's kind of a technical point, meaning that some states say that in order to have a modification, the change of circumstances have to take place with respect to the child or the primary custodial parent. And that strikes you as odd. You would say, well, why would that be? It would seem that the non-custodial parent, there could be a substantial change relating to you. Maybe formerly you were working 16 hours a day, 5-6 days a week. Suddenly you have this job that's entirely flexible. Maybe you're working 30 hours a week, but you're bringing in comparable income. Why wouldn't that be sufficiently important to trigger a modification opportunity? But I have to tell you that in some states, that's not enough. The court will look specifically at circumstances relating to the primary custodial parent and or the child. Now, among these facts, it does sound like there's a change with respect to mom's schedule. I think her schedule as well. But you need to look at that. It's an issue, of course, that your lawyer will